the ways to preserve these properties is through these kind of efforts that are made by the community, right? Now, what they say is that if anybody, supposing an encroacher creates a dispute, that property will lose its character as Waqf property as long as the dispute is pending. This is what the Act says. So you have a situation, where actually there was a Waqf Act. You just note this, there was a Waqf Act of 2013. 2013. Will you allow me? 2013, then, 1913, 1923, 1913, 1923.
What's in 1920?
213, 1913, 1913, then 1923, then 1913, 1913, then 1923, then 1954, then 1984, then 1995, then 2013 and 2025. This is the history of it. Yes.
Just factually, 84 and 2013 are amendments, not the...
No, I'm talking about the Act.
Yes.
Correct? So, therefore, and I will demonstrate to your lordships that the 2025 Act is a complete departure from the past. I tell your lordships how. There are two concepts in law called Waqf by user and a dedication which is made. Right. If you give a dedication, and you pass away and that property is used, for the purposes of the dedication, it becomes a Waqf by user and it's perpetuity. That's the concept of Waqf. Once a Waqf, always a Waqf. Correct, Now, that Waqf by user has been done. A concept that is recognized in the Babri Masjid case, saying Waqf by user is a practice, a religious practice that has continued for hundreds of years. That's the 5-judge bench, and whether it's a Waqf by user or not is a matter of evidence. But they've done away with it. How have they done away with it? They say that in the 1913 Act, the 1923 Act, the 1954 Act, and the later acts, there was a requirement for registration. And because you did not register, therefore, any Waqf which is not registered will not be regarded as Waqf. So many of these Waqfs by users were created 100 years ago, 50 years ago, 200 years ago, 500 years ago. Where will you get them?
Is it a matter of fact that under those enactments, 1913, 1923 and so on, is there a requirement for registration?
There was.
So is it a mandatory or?
They shall be registered, they said. But the consequences of non-registration were not set up in the Act. The consequences of non-registration, this is the first time in the 2025.
I have not gone through anything because I had...
That's why, I'm broadly telling your lordships what my submissions are going to be.
I have not gone through... I'll be frank, so you'll have to start from ABC.
Yes.
Just as a matter of information, whether under the old Act,
yes,
the provision was for registration was mandatory or direct?
The expression used was shall.
Merely using shall may not make it mandatory.
Correct.
Were there any consequences provided in those acts for non-registration? If consequences are provided, then it will be mandatory. Whether word shall is used or not.
The consequences were not that it will not be regarded as a Waqf. That was never the consequence.
Was there anything that on account of registration of a particular...
You won't be regarded as
something will happen?
No, there's no consequence that you will not be regarded as a Waqf. It will continue as a Waqf.
But there were consequences.
No, not this consequence.
So, but
the caretaker, there may be consequences, but not this.
Record your submission.
Yes, please.
That though under the old Act, there were requirements for registration, but they were not mandatory because the consequences for non-registration were not provided under those Acts.
For the purposes of deciding...
On account of non-registration,
yes,
nothing was to be happen.
Yes.
Like suppose if there is under certain Act, mandatory duty is there. You have to do such and such thing within a particular period.
Correct.
And if you don't do that, then you will be required to pay 1,000 rupees fine or 1 lakh rupees fine. So no such provision is there.
No. The only thing was, that the Act said that the mutawalli who has not done it is made culpable. That's all. He loses his right to continue as a mutawalli.
That's all.
That's all. As I said to your lordships, and I stand by that, there were no consequences provided that it will no longer be regarded as Waqf.
No.
Which is...
No other consequences were there.
No other consequence. Which is why the 2025 takes that away.
So
therefore, it's a complete departure.
So do we record that?
Yes, your lordships may record. It's a complete departure from the
1913. Till what was the last one? 1913 till 2013.
Till 2013. The status of the Waqf.
2013.
Yeah.
So
the status and character of the Waqf.
So there was a provision for registration of
Yes.
Waqf. No consequences were provided for non-compliance except removal of a mutawalli.
Correct, because he is responsible for registration of the Waqf.
So except removal of a mutawalli,
Consequences quay the mutawalli.
not a trust, not a waqf.
Correct. Well, that's for the community, Malat. So because he did not register, he will suffer the consequences, but the character of the waqf will not change and cannot. This changes it. I'm just giving you lordships broadly. This changes the character of the waqf. It says if you're not registered under these acts, then you're no longer waqf. That's number one. Number two, if you are a waqf by user, you must tell us as to who is the one who established the waqf. Well, how do we know? If it is established 200 years ago, how will anybody tell you today who established it? Because there was no registration at that point in time. They were user. That is why waqf by user is a matter of evidence held by the Constitution Bench of this court.
1913 to 2013.
Yes. Well, that's 23 was the first one actually.
Whether during 1913 to 2013, registration was not necessary insofar as waqf by user is concerned.
Yes. They have now removed it completely.
Was it permissible under the
Yes.
Act?
Yes. Throughout, Manoj. Otherwise, I wouldn't be making this submission. Waqf by user, this is established practice recognized by the Constitution Bench of this court.
Second submission is that prior to 2025, work by user was not required to be registered.
What happened was, Manoj, in 1954, for the first time, there was a requirement of registration as such. Otherwise, 23.
2020.
Your lordship may say prior to 1923 or prior to after 1954, Manoj. What happened was when the British were here, they didn't want to interfere in the practices, religious practical provisions or management provisions, Manoj, in those acts. But in 1954, it became mandatory that you must register. Now, who was to register? The mutawalli. The mutawalli was not
Prior to
registered.
1954, the registration of work by user was not necessary.
No, nobody was questioning waqf by user ever. Till date, Malaz. Nobody is questioning, except this act, except the 2025 act.
Probably you have not understood the question. What we have only asked, was it mandatory or required to be registered as a waqf under the acts prevalent at that relevant time as a waqf?
After
Maybe by
1954,
waqf
yes.
by user.
After 1954, yes.
So
Yes.
after 1954,
Yes.
the registration was mandatory.
Mandatory.
And it had
Even insofar as work by user is concerned.
Yes. Even by waqf by user. All waqfs had to be registered. Mutawalli had to register them. If he did not register them, then consequences followed way here.
on the Mutawalli.
That we'll see into
The
that.
waqf property did not lose its character as waqf. That's the point.
So according to you, prior to 1954, registration of work by user was not necessary and it became necessary after 1954. Was not necessary. Only after 1954 it became necessary.
Yes.
Only after 1954 it.
Malaj, there is some confusion on this, maybe after 1923. Your Lordship may write 1923 because,
Okay.
Yeah.
So we'll write.
say 1923, Malaj, not
We
1954.
are recording everything so that we can call upon them to answer all.
1923 because I've read the act myself. That's why I was saying 1923. 23, Malaj.
Problem is that so much of pressure
Yes.
not only builds pressure on us but also on you.
Yeah, exactly, Malaj. I got different discordant voices here.
So therefore we are
Yes, just I show you that the 23 Act says within 6 months from the commencement.
first we'll record your proposition
Yes.
so that
Yes, so that we know, Malaj,
My
what.
friends, not to disturb Mr. Sibal, my lord. He's continuously being disturbed from all.
That's all right. Don't worry about it. I'll take care of it.
Yes, sir. You must.
he is trying his best. We can see it in a better manner.
Yes, yes. Others may not disturb.
We can see it in a better manner. He has tried at least half a dozen times.
So therefore, that's the proposition. Let's make it 23, not
Okay,
54.
24. After 23 it was necessary.
Yes, necessary. But no consequences square the dedication.
So that we already recorded.
Yes. So, Malaj, that's the second proposition. You take away waqf by user. Third proposition is, Malaj, just note two dates, 1904 and 1958. These acts relate to Ancient Monuments and Archaeological Sites and Remains Act of 1958. And there is the 1904 Act, which is also here, which is the Ancient Monuments Preservation Act of 1904.
Ancient monument.
Preservation Act 1904. So two acts, 1904 and 1958, both dealing with ancient monuments,
Both 1904 as well as 50.
and 1958. When this 1904 Act came, Malaj, as your Lordship knows, waqfs were there. The
The
dedication.
works will, from centuries you are saying that there.
Waqfs have been there, Malaj. So what the Act did not interfere. For example, Malaj, you have, say, the Jama Masjid or any other places of worship. It's a waqf, but it's getting dilapidated, right? So the government can say, we want to preserve this property. We want to make sure it doesn't get dilapidated, Malaj. And therefore, they give a notification saying that for the purposes of preserving the property, it is declared as an ancient monument, right, Malaj? But it doesn't lose its character. Doesn't mean that you can't go and pray there.
So though it is preserved as an ancient manual?
No
interference with the
ownership,
market.
no ownership was transferred to the government, and it doesn't, you couldn't stop the user of the Waqf property for the purposes of the dedication. Couldn't change the identity either.
Like in